Okay, so we're going to get started so we can get a lot of bang for our buck, so to speak. And welcome. It's John Grossman trying to help you with MBE tonight. Hopefully bar prep is going okay. I always like to say this is the worst time of bar prep. You kind of got over the whole hype and adrenaline rush of starting. Now you're kind of knee deep in all the outlines and the material and of course your practice questions, let alone your state portion, whatever jurisdiction you're doing, and you're kind of hitting the wall. You get a little burnout now. So did a couple thousand questions already, did too many questions, not enough questions, but you're about to start, but you don't like multiple choice. The next 45 minutes are about how to give you a little more practical approach in reading the questions. So you're not just doing a lot of questions. People always email and call me, I did 3,000, I did 5,000, but I can't break 57%. Or John, some days I'm at 70% and some days I'm at 50%. How do I get that balance? That's what we're going to talk about tonight. Practical tips, strategy, an actual system, an actual way to read every single question. So you should know why the answer you're picking is right. And more importantly, you should get a little more confident and aggressive as to why the other ones are wrong, as opposed to the proverbial getting it down to 2 and just going eeny, meeny, miny, mo. Although AdaptiBar has the best practice questions on the market, the questions are only as good as your approach on how you're reading them. You can't just do 5,000 questions and all of a sudden you can practice your way out. If your overall system, if your fundamental of reading the questions is a little off, then the numbers are going to be a little off. So we fix it tonight using some sample questions. We're going to walk through a couple. We'll try to get to one of each subject, time permitting. These questions are on the National Conference of Bar Examiner website, as you see down there at the bottom. These are on there's free sample MBE questions on the National Conference of Bar Examiner website. We are doing these with their permission. There are sample MBE, I think there's about 20 or 21 total of a page. You can do that on your own on the ncbex.org website. Hit the MBE link and you're bound to find the sample questions. So we're doing these tonight with their permission. And we'll get, like I said, to as many as we can. And then we'll take some questions like always at the end. Okay, big picture. Let's jump right in and talk about overall approach. What I thought I would do is I'll give you the basic rule. We're not trying to test anybody right now. Give you the overall rule and then give you a few moments to read it. And then we'll kind of walk through the questions. Okay, but let's talk about overall approach, big picture, big approach to MBE. Okay, there's a whole argument about the call of the question. What do I read first? What do I worry about time? I'm going to go into this in as much detail as I can, but as a free commercial, I go into a lot of what I'm going to say tonight in a very specific, detailed lecture that's also on AdaptiBar called Mastering the MBE. So if after this you feel like maybe I was making some of these mistakes, he's kind of talking to me, this is what I kind of do on multiple choice, but I need a little more detail, want a chance to review it, look out for that standalone video called Mastering the MBE. That's all about approach to doing MBE questions. So if you feel you need a little extra help with approach, that's what that lecture is for. Okay, we'll talk more about that later. Overall, here we go. What's the big problem with looking at the call of the question first? Should I or shouldn't I? You can do whichever you like. But if you take a look at this first question, this is a tort question. In a suit against a man, is the neighbor likely to prevail? So when people read the call first, they think that's going to tell them something. Some people will say to me, you see, I know it's a tort question now, John. Okay, but since there's like 40 torts they're going to test you on the MBE, you don't know which one. The problem is when you look at that call and the call doesn't tell you anything, just human nature, where does your eye go after you see that? To the answer choices, because most people want to avoid the facts in the first place because they think they have a time issue. So they think they're saving time doing a shortcut. If they look at the call, that's going to tell them something. Here's a perfect example where that doesn't tell you anything. If you now look at the answer choices too quickly, what happens? What I'm about to go over with some subjects. In the answer choices, on average, they're going to be giving you elements, pieces, references to 3 or 4 different torts. The reason most of the country gets it down to 2, changes their answer, overanalyzes is because you're looking at all these answers that make good arguments you would include on an essay, are legally and factually true statements. but they're not the correct answer because they're not specific to the issue. What's the issue? You don't know if you're looking at these 4 answer choices right now because you didn't read the most important part of every single MBE question, no matter what's the subject, which is the fact pattern. The fact pattern tells you everything that you need to know. So I say to people, if you like to look at the call, go ahead. But where shouldn't you look right now? The answer choices. You got to go back to the facts. You have to see what the question's really about, so you literally know what you're looking for. If you don't know what answer you're looking for, you're just basically making educated guesses. Number 2, they're going to give you a lot of, as I said, legally and factually correct statements in the answer choices. That's the one, the other answer you like to get it down to. Why are those answers that are legally and factually true not correct? Because again, you always have to pick the most specific answer to what the facts are talking about. That is the key. What is the most specific? Not the best, not the strongest. That's all stupid garbage. There aren't 3 good answers and you have to find the best one. There's one single answer which specifically answers this particular hypo, as is the case with the other 199. So if you find that you're picking an answer, which technically is true, there's nothing wrong with it, it's usually wrong because it wasn't specific to the issue. You get it down to the right conclusion, yes, yes, no, no, guilty, unconstitutional. If you're getting it down to the right conclusion, but you're getting the question wrong, what does that mean by definition? It means you didn't know what the issue was. Because the 2 that always come to the same conclusion, the 2 yeses, the 2 nos, the 2 liables, the 2 constitutionals, they're never discussing the same tort, crime, or amendment. They're always talking about different issues, different torts, different crimes. Your job is to know what each answer is about. So quickly, I just want to give you a preview of this, which is, here's something I recommend. You can do this verbally. You can have a piece of paper where you write this down just instinctively. Here's how I like to look at the answers, okay? You see where it says issue. So if I know my question is about battery, negligence, larceny, burglary, once I know what my issue is, what is the rule on MBE that you're only going to hear with us? Once you know what the issue is, your answer that you bubble in is required, shall be the most specific answer to that issue. Once you know what tort they're testing you on, your answer must be about why or why not that tort occurred. You can't go, well, I don't think it's battery, but it could be negligence. Can't be murder, but it could be manslaughter. Once they name the issue, your answer must only be about that. So if you're realizing that your answer that you picked is technically true, but it's wrong, it's because it wasn't about the issue. You didn't do what I call connect the dots. Once I know the issue, I'm going to connect it to the most specific answer. I give you this chart because what I'm trying to get across is each answer A, B, C, D for every single question on the bar will be referencing, talking about another tort, another crime, another amendment. That's what's called those distractors. They get you reading those answers and thinking, you know, that sounds pretty good. So does that one. That's pretty good. And then you start thinking too much. But A, B, C, D are literally talking about 3 or 4 different concepts, different rules. So no matter how good you like your answer, if it doesn't connect with the issue, you can't pick it. So whether you like to draw something like this out, just make a note next to the answer choices on your legal pad, whatever, turn the questions into what I call a little puzzle. It becomes too much like analysis. Just focus on each answer one at a time, A, B, C, D. So if you basically in your head or on paper, jot down the name of the tort, no, it's not going to slow you down, because what's going to happen? Even if it took you an extra 15 seconds to do this, by the time you do that, you'll literally know what answer you're looking for, which stops you from getting it down to 2, and it stops you from doing the other thing that most of the country does, which is having to reread the hypo over and over again. If I know what's going on here, then I know what I'm looking for. The wrong answer should fall away much more quickly. So I do this chart just to try to emphasize how mechanical, what I call cookie cutter. You're not trying to look at this as analysis. You're trying to say, here's my issue. He's not liable. Where's the answer that says he's not liable? Connect the dots. This is equal protection. It's strict scrutiny. Where's my strict scrutiny answer? This is impeachment. It's coming in. Where's the impeachment answer? Best evidence rule? No. Character? No. You should be able to go down those answers knowing what each answer is about. And if that answer choice is not about your issue, it's got to be wrong. So let's show you a couple of classic examples of what, quote, they're doing to you. Rule, strict liability. You're doing a tort question, strict liability. There's two activities you can be strictly liable for. Wild animals, abnormally dangerous activity. If you're engaged, if your wild animal injures somebody or you're engaged in abnormally dangerous activity, you're automatically strictly liable. What's the one legal defense to strict liability? Assumption of the risk. John preaches, never pick a defense or an exception unless that's what the fact pattern is talking about. How will you know that the hypo is actually talking about the defense or the exception? Because they will tell you. Strict liability, wild animals. Are dogs and cats usually wild? No, those are domestic animals, and therefore there's no strict liability. Except, can a domestic animal become wild? Yes, if the animal has, excellent, dangerous propensities. How will you know if the dog or the cat or the other domestic animal has dangerous propensities? Because they will tell you, reading comprehension. And where are they going to tell you all this information? In the most important part of the hypo, the facts. Don't look at the answer choices here. Just take a look at the facts in the question. I'll give you a moment, and then we'll walk through it. Facts in the question only, and then we'll walk through it. Okay, so again, you're just looking at the call and it says in a suit against a man is the neighbor liable. You don't know the name of the tort. That's why when you go to the answers, you don't know what you're doing. But what's the fact pattern about? It's about a dog injuring somebody. Well, what tort should you be thinking about if you see a dog injuring somebody? Strict liability. Normally, the dog is not considered a wild animal. So normally I would know there's no strict liability. But is this a bad doggy? Yes, and you know it's a bad doggy because they told you. Ferocious dog, wild animal, strict liability. The owner is automatically strictly liable. But is that where the fact pattern ends? No, John, because assumption of the risk here is present. How do you know that the guy assumed the risk? Because they told you. Because he actually read the sign telling him da-da-da, and he understood what the hell he was doing. He understood, read, that's called assumption of the risk. You appreciate the nature of the danger and you go ahead anyway. Look how much information that fact pattern had. It was a dog. If you just see dog and you jump, you miss the whole point that this is a ferocious dog and therefore there is strict liability. If you said, oh, strict liability, let me go down to the answers and find the strict liability answer. Again, you went too fast because here they, in fact, did give you the exception, which normally you don't worry about, but here they, in fact, did. So before you ever look at the answer choices, what should you already know? It's a strict liability question. That's my issue. There was a wild animal, but in this case, there actually was assumption of the risk. So I know, here's the two things you need to know. I already know what my conclusion is, but I know why. Not just the no's or the yeses. Because even if you know it's no, there's two no's, and that's why people get it down to two. So what do? You literally say it's strict liability, assumption of the risk. So he's not going to be liable because the guy assumed the risk. Now I know why. Now I know what to connect the dots to. My answer must be connected to assumption of the risk because that is the applicable defense based on the facts to strict liability. Let's walk through them together and show you why you're missing even simple tort questions. Read A by itself. Notice that A did not say yes because he assumed the risk. They didn't give you the buzzwords. They didn't. But is A the plain English version of what you were looking for? Yes. Hold that thought. Look at B, coming to the same conclusion, John. Take a look at B. What's the most important word in B? What is B about if you're going back to my little chart, A, B, C, D? A is clearly assuming the risk, though in plain English. B, trespass. Trespass, that's another tort, John. If I was writing an essay, couldn't I argue trespass? Yes, but are you going to talk about trespass here when there's a ferocious dog? No? Excellent. What sound should you be making with your number 2 pencil when you read B and you see, although he could argue he was trespassing, that's not the issue here. The hypo is all about assuming the risk under strict liability. If you're thinking assume risk and you see trespass, what sound should you be making? Whoosh. Don't put a little asterisk next to it. Don't put a little smiley face next to it. I'm going to come back to that one, John. There's nothing to come back to. The only thing you're going to come back to is the convention center, God forbid, 6 months from now. You don't want to come back to anything. I know B is wrong because B is talking about trespass, and I'm doing a question about assuming the risk under strict liability. C, forget the conclusion. Read C. What is C about? What is C referencing? Invitee. When do I talk about whether you're an invitee? When we're talking about the duty of care under negligence. Can I pick a negligence answer to an assuming the risk strict liability question? No. D. There's your Pavlovian dog, no pun intended answer. Oh, abnormally dangerous. See, I would have thought about strict liability, John. I get your point. If you get into the answers just 5 seconds too quick, okay, dog, wild animal, strict liability. I'm going to go with abnormally dangerous. Abnormally dangerous has the good, juicy legal terminology, even though it doesn't say wild animal. If you're thinking only strict liability, a lot of people will pick D. Some people will pick B because it's giving you a legal term like trespass. And even though they know this assumption of the risk, they don't like to pick A because it's in plain English. I'm telling you, the reason you're here is, as you've probably found out from a lot of other questions on AdaptiBar, the real ones, many hundreds of answer choices that are the correct answer to the question are not giving you buzzwords, but they are the most factually specific to the issue. Connect the dots. You had a assume the risk answer in plain English, a trespass answer, a negligence invitee answer, and a strict liability answer. 4 different answer choices. That's what they're doing on hundreds of other questions. So if you pick, you got it down to A and B because you knew was no, you have to always contrast the difference between A and B. One's talking about assuming the risk in English, one's talking about trespass. They have nothing to do with each other. If you got it down to A and D, because you said, well, I know it's strict liability, John. I went too quickly now. I see. So if you get it down to the 2, A and D, because you know it's about strict liability, and you pick D, it's because you didn't pay close enough attention to the facts. So when you're getting it down to 2, always be asking the why, the why, the why, the why. Never the best, never the fastest. Slow the bleep down. So let's quickly talk about time. Even if you have the proverbial 1.8 minutes, which is somewhere between 1:40 and 1:50. Most people do skim, skim, skim. Let me look. So you're spending 30 seconds or 20 seconds here and 3 minutes down there going eeny, meeny, miny, mo, or rereading. I'm suggesting as you practice now through July and doing 30, 40, 50 questions, slow down in the facts and the call. Take 1:30 if you need to on the longer ones. You wouldn't need that on this one, but make yourself slow down and ask yourself, what's the issue? What am I looking for? What is it about? So if you did that on this one, look how fast you would eliminate 3 answers and you get the right answer in 5 seconds. It's not, you're not slowing down overall. You're just slowing down to make sure you know what the heck you're looking for. So when you get into the answers, you're not going, I don't know. Let me get it down to 2. Issue, rule, fact in the hypo, know what answer you're looking for, and always be asking, why is each answer, what is each answer about? Therefore, why is it wrong? There is no best. There's what is each answer talking about. Let's do one. Here we go. Let's do a crim law one. Nice and easy. Here we go. Take a look at the call of the question here. President was convicted of murder. Should the conviction be reversed? They made it a murder question. So here's your opposite example I wanted to show you. In the first one, it didn't tell me anything. Here, they told me it's murder. But as hopefully you know from my lecture, how many kinds of murder are there at common law? 4. Intent to kill, intent to inflict serious bodily harm, felony murder, depraved heart murder. How do you act under depraved heart? Reckless disregard of human life, recklessly. Reckless means you knew or should have known, knew or should have known. Once they make it a murder question, you can't go down. You have to know which one of the murders the question is talking about. How will you know which one of the 4? They're going to bleep and tell you where in the facts. Take a quick look at this little hypo here, and then we'll walk through the answers. So for my district attorney and public defender wannabes out there, don't litigate these questions like I always like to say, because many of you are going to disagree with some of the conclusions the questions come to. I agree with you. Don't do that. What should you be thinking? It's murder. There's 4. Which one of the 4 is this whole hypo about? Depraved heart. Depraved heart. They knew or should have known. They knew or should have known what this was about, and they did it anyway. Let's say you didn't even recognize that because it's a weird hypo. What's the key I'm trying to get across tonight? Once you know what the issue is, your answer is required to be only about that issue. Don't go outside the box. Once they make it a murder question, whether you think they're guilty or not, the answer must only be about one of the 4 kinds of murder. And which one did this hypo talk about? They knew or should have known, and they did it anyway. Depraved heart. Let's go read A by itself, please. Strict criminal liability. What does strict criminal liability have to do with murder? Nothing. What sound should I hear across the country? Whoosh. B. Does B look bad or does B look beautiful? Come on. Does B have a good word in it? Reckless. Is B your depraved heart answer? Can you connect those dots? Even if you disagree, is B if we're going back to my chart, is B equal to depraved heart? Yes. C. What is a regulatory offense, John? I have no idea, nor do I care. And only an idiot would pick that answer, because what does regulatory offense have to do with murder? Nothing. You must connect the dots. Put the blinders on. They made it a murder question. Be mechanical. Your answer has to be about one of the murders. Now, here's the reason you're here tonight. Take a look at D. Proximate cause. Proximate cause. I wonder. When do I think about proximate cause? Negligence. And when are you negligent and causing a death? Manslaughter, involuntary manslaughter. Negligent conduct causing a death, manslaughter. We're doing a murder question. What do those 2 things have in common? Nothing. What's the only one of the 4 even remotely on point to one of the 4 murders? Be beautiful, as John says, shut up and pick it. That's correct. You see why those 3 answers are wrong. A and C are stupid, and D, proximate cause, duty, breach, any negligency answer where there's a death is involuntary manslaughter. Hundreds of people email me this time of year. Can you remind me about that reckless negligent thing? This is what I said to you guys last month. If you get to this stage in bar prep and you realize, I think I'm getting sloppy with some of these words, I got to go back and review, you do it. Doing 50 more crim law questions, if you're forgetting these buzzwordy definitions, would be ridiculous, because you're going to miss all the questions. It's a bad use of the questions. Take an hour or an evening and get back to basics with the rules, then go practice the questions. If you do know, and you're still getting it down to B and D, what is the issue? Murder. Even if the litigators out there say, I don't think this would be murder, John, I'm going to go with manslaughter. You can't do that on MBE. Why? Because they made the question about murder. Connect the dots. Once you know what the issue is, whether it's in the call or it's in the facts, that's what the answer must be about no matter what. Don't go, it can't be this, but it could be that. That's why you want to focus on the issue spotting, and you can only do that if you slow down. Excellent. Let's take a look at another one. Okay. Yes, sorry, we'll do this one here. Civ Pro. Everybody hates Civ Pro. Okay. Don't look at the answers. Just read the facts and the question itself. Okay. They made this about judgment as a matter of law. The issue, they told you it was judgment as a matter of law from the facts. And what's my rule for judgment as a matter of law? And what do they like to try to do? They like to try to confuse everybody between judgment as a matter of law and summary judgment. Rule, summary judgment, no genuine dispute of material fact. Judgment as a matter of law, a reasonable jury does not have enough evidence to find for the party. Reasonable jury doesn't have enough evidence, not an evidentiary basis. The key with judgment as a matter of law about whether there's enough evidence or not. Summary judgment, no genuine dispute. Here, based on the fact pattern, did the bartender, did the tavern do anything wrong? They're sued for negligence, they're sued for injuries. Did the bartender do anything wrong? No. Is there any evidence that these guys were negligent? No. This guy was an idiot. He did his own thing. Yes. Now I know what I'm looking for, because what do I know? What do I know that the answer must be about? Whether the jury would have enough evidence to find for this guy. And you know that they don't, because that's what the fact pattern was talking about. Correct? Correct. Excellent. Excellent. Let's go into the answer choices. If it's about judgment as a matter of law, and I know that the tavern didn't do anything wrong, I literally know what answer I'm looking for. Take a look at A by itself. They're giving you some buzzwords about what a jury could conclude, but is A factually specific to this hypo? No. B. Whoosh. C. Does C look like what I'm talking about? I'm going to grant the tavern's motion because there's no evidence that they did anything wrong. Does that look specific? Even though A was trying to get you to talk about the jury thing, that was the opposite conclusion. That's why you need the facts. Don't jump for the buzzwords. Take a look at D. When you see the word dispute or undisputed, what do you think they want the country to be thinking about? Summary judgment. No genuine dispute. That's what I think anyway. They're playing with the buzzwords. You with me on this? So if you make the mistake because you got it down to C and D, but you pick D, usually it means you got confused between summary judgment and judgment as a matter of law. That means don't run and do 50 more Civ Pro questions. I got to go back to the basics and get that rule straight in my head. If you knew the rule, usually those people get it down to A and C because they know it has to be about one of those. And if you're not sure which one of those, again, what does it mean? You didn't read the facts carefully enough. Always be asking what? What is each answer talking about? What is each answer talking about? That's why I like my little chart. Underline, circle, next on as you're looking at the answer choices. Write down a word, strict liability, negligence, dispute. You get my point? Come up with your own little shortcut. Even what's going to take you 10 seconds, but the 10 seconds is going to make you more aggressive in your ability to eliminate those other answers rather than staring. That's what everyone's doing. They're flying through the hypo to stare, and then it's 2.5 minutes later and you don't know what you're doing. or you're just picking the first good-looking thing you see, like words like abnormally dangerous or jury. They're baiting you by making you go too fast. That's what we're trying to avoid. You don't want to be going too fast. That's what you're trying to do. Another one, evidence. Evidence. There's impeachment evidence. There's character evidence. What's impeachment about? There's two ways you can impeach a witness. Remember, impeachment is always about the witness. You can either impeach the witness to contradict what the witness said, to attack the witness's credibility, buzzword credibility. You're either attacking what I said by bringing in contradictory evidence, another testimony, another witness. You're doing something to make the witness look like I didn't know what I was talking about, contradicting or catching me in some sort of a lie or an inconsistency. Or you're impeaching the witness with my own prior bad acts. Are you generally able to impeach? Yes. As long as you're attacking my credibility, you can impeach me. Show you how weird this one is and how easily you can dumb it down. Don't again look at the answer choices, look at the facts and the question. Okay, so you see, the witness denied making the statement. Now what does the prosecutor want to do? Wants to bring in the grand jury testimony that he did in fact say this. Notice the question here. Should the court rule? How should the court rule with regard to the testimony? That doesn't tell you whether it's hearsay, impeachment, character, or the best evidence rule. You with me? The call of the question didn't tell me anything. That's why people who think they know a lot of evidence and do get a lot of these wrong, because they look at the question, they say, I think it's coming in. I don't think it's coming in. You're focusing too much on the conclusion and not the issue. You don't know what the issue is just from reading the question, because it doesn't tell you. How will you know? The fact pattern. So if you took the extra 30 seconds to read 4 lines of fact, he's saying he didn't make the statement. Now they're trying to show that he did make the statement. They're trying to contradict him. They're trying to impeach him. You with me? 20 extra seconds of reading comp and what I call dumbing everything down. What is the fact pattern about? On a stat, whatever it took, I would be screaming from the top of the biggest mountain. The better you do on these questions is based on more careful reading in the facts. And the slower you go here, the faster you're going to go into the answer choices and eliminate the wrong ones. Because once you identify, notice nowhere in the facts in the call of the question did they use the word impeach. That's your own issue spotting. But that's what every 3L knew how to do to get a JD, issue spotting. That's what the final exam was about. But instead of on your final exam spotting 15 things to BS about for 3 hours, now on the MBE question, you only have to find one, which is why John's always screaming, what's the issue? Not what are the issues, not what's the strongest argument. What's the single issue this hypo is about? They're trying to impeach him, John. Can you generally do that? Yes. Let's take a look at answer A by itself. Statement by party opponent, that's an admission. That's something called non-hearsay. What does it have to do with impeachment? Nothing. What sound should I hear? Whoosh. B. I'm going to get to where you're at. John, when does it come in just for impeachment and for substantive view? I'm going to get to that in a minute. But is B your impeachment answer? Is B referring to impeachment? Yes. Hold that thought. I'm going to get back to it. C. Yeah, that's clearly an exception, John, to hearsay. What does that have to do with this? Nothing. D. Testimonial. That's not about impeachment. Is there literally only one answer talking about impeachment? Yes. Can you and should you be able to connect those dots if you knew it was an impeachment question in the first place? Yes. Now, here's the other thing they're doing to you. Sometimes they're giving you the correct answer in plain English. You don't like it because your courses and your books told you it had to be the legal one. No, that's why you're here. You always pick the most specific answer to the facts. Note 2, sometimes you're getting the, you know the issue, you know the law, you're getting the right answer, but they throw in those extra words, those phrases you've never heard of, you don't like, doesn't match your card, what I like to call my front rowers, right? If the answer doesn't look exactly like my flashcard, John, which is all color-coded, I get a little intimidated, John. That's what I'm trying to get across by a question like this. I'm telling you, Uncle John's telling you, that many times the correct answer includes and adds words or phrases or a rule you don't remember, you never heard of, or you just don't know. What do? Shut up and pick it. Because is B your only impeachment answer? Yes. So what the hell else are you going to do? Pick hearsay? Pick admission? That's what they're doing to you. How many times did you think you knew the answer, but you didn't like it, so you went with the other one? Even though in your gut you knew the other one was irrelevant and ridiculous. I've done that a couple of times, John. That's the difference between 55 and 65, 59 and 65. Those 4, 5, 6%, I knew it, but I didn't. Shut up and pick it. Connect the dots. There is a rule. There is a rule. This is called the inconsistent sworn statement. So because this statement was made in a grand jury, it was made under oath. This is where the other non-hearsay rule. If it's a prior sworn inconsistent statement, then it can also come in for substantive use. This is why that extra sentence, that extra half a sentence comes in, just in case you were wondering. If you see a hypo, usually when they impeach somebody, the statement you're impeaching the guy with was not made under oath. So it's just impeachment. And that's why usually the answer is only for impeachment. If you see an answer, a hypo, where they say that statement that you're trying to impeach the guy was in fact made under oath, then that's one of the examples where it can also come in for substantive use. Also can come in for substantive use. That's one of, there's a couple of other examples. This is the one they're applying here, okay? We're not trying to redo the law right now, just showing you approach by the fact that they could throw in that extra half a sentence that you may not remember. But even if you're thinking about another rule, I keep coming back to the point, what other answer would you pick? There's a statement against an admission answer, an impeachment answer, an exception to the hearsay rule, and testimonial. Is this an impeachment issue? Yes. Shut up and pick the simplest and most specific answer to the facts. It's impeachment. Even though I'm not sure about the other half, there's nothing else I can pick because I must connect the dots. You're either not spotting the issue here because the call of the question didn't tell you, and you either read too quick or focused on the answers too quickly. Got to go back to the facts. You're right, John. I got to slow down a little bit. Or I saw the issue and I know the rule and I'm letting the language and the answers get in my head, distract me, so to speak. Always be asking what each answer is about. When in doubt, slower up here makes you go faster in the answer choices. Always be asking the question, what is each answer about? Once I know my issue, A is about, B is about, C, D, which one? What if I get it down to 2? They will always come to opposite conclusions. Yes, no, guilty, not guilty, constitutional, unconstitutional. The 2 will always come to opposite conclusions. How will you know which one to pick? What were the facts talking about? Fact specific. Sometimes the correct answer is the buzzword. Sometimes it isn't. When it isn't, it doesn't mean it's wrong if it's the most specific to the facts. Sometimes they give you the obvious answer, but they include some funky language because they're trying to intimidate you. Do not let them intimidate you. I already know what I'm looking for. That's what we're talking about. If you know you passed the MBE, if you can leave the room, look yourself in the mirror and say, every answer I bubbled in was the most specific answer to the facts. Again, it always has to be fact specific. Again, how will you know if if there was diversity? Because they have to tell you if you lived in New York and I lived in California. How will you know how much the case is about? Is it 75 grand? Is it 20 grand? How will you know all the answers? How will you know where the defendant resides for venue? The facts will tell you. The facts will tell you. I can play this game till 11 o'clock at night. Every question is going to be based on what the facts said. When in doubt, err on the side of the facts, the facts, the facts, and the facts. That way you know what answer you're looking for. Your goal is to connect the dots. I'm the one telling you, you will not like every answer, you won't agree with every answer, and you may argue with some of the conclusions the answers come to. I agree with you. Shut up and pick it. Once they make it a murder question, you can't pick manslaughter. Once they make it a character question, you can't pick impeachment. Well, I mean, this wouldn't be battery because there was no intent, but I'm going to go with negligence. You can't do that. If they say John sues Bob for battery, your answer has to be about why the battery didn't happen. And there's going to be one answer talking about a lack of intent. But don't say, no, I don't think it's battery. I'm going to go with negligence. If you get the battery question where there was no intent, there's probably going to be an answer, yes, because there was a harmful or offensive contact. They're going to give you an answer that gives you some of the juicy buzzwords. The reason that answer is not going to be correct is because that's not what the facts we're talking about. If the whole hypo is about the lack of intent, then my answer has to be about the lack of intent. Always be focusing on the facts. Fact, fact, fact. Connect these dots. Look at these questions as little puzzles, not legal analysis. And the more mechanical you can get, the more, even when you don't like it, you're going to force yourself to shut up and pick it. You will see a shocking turnaround in your stats. That's why John's always saying, do fewer questions till you rewire your brain to slow down here. So when you look down there, you're more specific about what you're looking for. There's more of this on the Mastering the MBE video. If you feel you're making too many of these mistakes, I don't like to sound like a used car salesman, but hey, that's why we're here. That lecture, about an hour and a half, will go into a lot of detail about this issue spotting and what you do to do each question exactly the same way. Again, I repeat, though, if you're getting a couple of questions wrong because you're confusing the rule, that's why you want to go back to the outline and make sure that you're focusing on the right definition. On the video page on AdaptiBar, there's a standalone video called Mastering the MBE that's on the video page on AdaptiBar. I'll be happy to open it up for any questions for a few moments before we let you get back to doing some questions. I tend to take too long on questions because I'm afraid to get the question wrong. How do I get over that fear of getting the question wrong? Great question. I hear that all the time. Again, you can't be afraid of getting the question wrong because bluntly it becomes a self-fulfilling prophecy. You're afraid, quote unquote, because either you know where the question's going, but you're afraid to pick something. That's why no kidding around John preaches, shut up and pick it. Shut up and pick it. I got to trust what I'm reading. So if you're afraid because you know it's A, but I'm not real, you got to let it go. You know what they say about real quarterbacks? Not the jet quarterbacks, but real professional quarterbacks. They say, trust your eyes, trust what you're seeing, let the ball go. That's what you need to do. You must begin to trust or else you're not going to give yourself a fair chance. If you're wrong, then just be honest with yourself. You missed a couple because of some rules. You put that back in your head. You miss a couple because of the reading. No problem. Go back to the facts, but don't be afraid. You've got to be aggressive and you've got to be confident. That's why you're practicing now, right? Practicing is just practice. Learn from the mistakes, figure out why you're getting some of these wrong, and all of a sudden you'll be okay. Good. Anything that begins with a 6 in front of it right now, you're doing pretty good. If you're in 60 something in any subject, you're generally doing okay. You know, as you go, you should be getting a few more right because you're being more comfortable with more law and you're making fewer and fewer of these reading mistakes, which by definition will improve the score. So anything with it, if you're in the 50s, nothing's wrong, nothing's terrible. It usually just means maybe I'm trying to do too many questions too quick and I got to go back and fix some of these rules because otherwise I'm guessing, or you're making too many of these reading mistakes. And that's why you just need to ask yourself, if you're doing AdaptiBar questions, the first thing you do when you get a question wrong is, what's the red, what's the green? The green answer is talking about impeachment. My answer is talking about character. Jesus, this is obviously my problem. I went with the wrong issue. Oh my God, I didn't spend enough time in the facts. Look at the difference between the red and the green. If you know it's a larceny question and you picked the larceny, he was guilty, but the answer was he wasn't, that means you know the law and you knew it, but you must have misread the facts somewhere. If you picked murder, but the answer was about manslaughter, you got the wrong issue. That's again, reading comp. You with me? So no matter where you are with those mistakes, usually the answer stems from issue spotting and reading the facts specifically. That's what we need to be focusing on. Not how many questions, doing more questions slowly and more specifically on what's in the facts. Better reading comp, quality over quantity. Stamina is the last thing that's going to improve. Hopefully by July, when you feel as good as you can about the rules and your lectures are over, hopefully by the next week or two, you're feeling better when we finish. You finish your lectures, then you do more practice because you're not reading and watching video all the time. That stamina is going to happen. But as I always say, to a big point, if you find that you're getting tired after question 20, 30, or 40, hey, maybe I need to put the pencil down and rub my eyes and rub my neck for 5 or 10 seconds, take a breath, and then go. Is it worth the 5 or 10 seconds? Yes, because once you're doing this and glazing out at the screen, it doesn't matter how many questions you're doing. Stamina will be the last thing to build, but get good fundamentals. Speed is always the last thing in any skill that takes over. But the more you're doing well, the more consistent you are from question 1 to 11 to 40 to 50, speed will take care of itself. As soon as you find yourself glazing out a little bit, that's where you put the pencil down, rub your eyes, rub your neck, take a deep breath, shake your head. Okay, let me just go read another 5 or 10. Slow building good building blocks. I read more consistently on 20, 30, 40 questions. That's what I'm going to do on all 200. Build from the ground up with a momentum and always be contrasting what each answer is talking about. We'll be back another time with more stuff about where you should be and all that. What you should really be worried about right now, and the focus for tonight should be, am I reading better? Can I improve my reading? Can I get more consistent? Can I make fewer of these kind of mistakes? That alone will have your percentage going up. Then when we come back for the next one of these, we'll talk about where you should be on the bar. I'm not trying to ignore the question. I just want you to focus on right now. Too many people are already worried about July, and all they're doing is making the same silly mistake over and over again. So be more careful, more focused about what I'm doing on each one of my questions right now, so that I, by definition, will get better with my reading comp, and you'll see your percentage eke up a couple of percentage points every couple days, every week, etc., as you go forward. Issue spotting, reading comp, slow down here, you go much faster down there. What is each answer talking about? It's even more important on the longer hypo, because lastly, I'll say, and then we'll go. The longer the hypo is, the easier the answer is going to be. All they're giving you in the long hypos is more BS. So if you get comfortable and you build up your discipline and your patience, really feeling more confident in my ability to issue spot, knowing that most of that hypo is a bunch of garbage, somewhere in there, 1.5 sentences will tell you what the issue is all about. When you do that, you will be shocked how often there's only one answer even remotely on point. But if you do the one finger skimming to get to the bottom, that's why you don't know what the hell to do. I guarantee you, in honor of my hero, Broadway Joe Namath, who guaranteed the Super Bowl, I guarantee you that if you get more comfortable knowing most of this fact pattern's a bunch of garbage, it's really about delivery. It's really about the deed. It's really about this. It's really about that. Once you get more comfortable with that issue spotting here, you'll know exactly what answer you're looking for, and you will be shocked how often there's only one answer, even remotely on point, and then you know what to do. Shut up and pick it. You need more detail on this, check out the video page for Mastering the MBE. Focus on that good reading comp and slowing down, and I'm very, very confident you're going to see a big difference in your overall percentages and stats moving forward. Always be focusing right now on quality more than quantity, and then in July you'll have plenty of time to increase the numbers and all that stuff. We'll look forward to seeing you one more time. I really appreciate you taking your time out of a busy time right now. I know this part of bar prep sucks. Keep your head above water. Just stick to the rule. We're all here for you. Use the best questions that are on the market. Just don't do them too quickly, because then you're basically wasting the question. But hang in there, stay tough, and stay confident, and stay aggressive, and keep saying shut up and pick it. Don't second guess yourself, and don't be afraid. We'll look forward to seeing you really, really soon. Take care. Thank you.